into our first little part of this lesson. And so, as I can see it, there are two things we need to be mindful of. And in this journey as we go along, and how to be a good contract drafter. And one is how to write a contract, and the other is how to think about writing a contract. But use of recitals, she would say to use them sparingly, and there are some instances where you may. But for our learning, we need recitals because that is where we're going to be able to discern what issues are relevant. And so you're going to have some very technical transactions. The only way that you're going to be able to understand what's going on in that transaction, it may be, is for you to pull out the relevant information and put it in those recitals. Okay? That's how, so I am saying don't just use a whole bunch of recitals just for the fact of using, but whatever recitals will be relevant that would coincide with the business goals of the client's issues of concern, then you would want to reflect that in your recitals. Because sometimes, although they don't bind the agreement, sometimes, and hopefully, our goal is that we never end up in court, but sometimes it will be the judge's reading of those recitals to understand why we entered into this agreement in the first place. What was the objective of the client or whoever it is that's ending up in court? And so these are just examples of things that will go into your thinking in how to write a contract. When you get ready to really put the pen to the paper, tabulating and false imperatives. These are, things about writing the actual contract. But then we need to also learn how to think about writing a contract. And so these are those things that would be decisive in learning how to think about writing a contract. You're going to hear me say over and over and over again, what was the client's goals? What was the client's issues of client concern? Issues, goals, issues, goals. What risk? These are things that you will see as we go on will be what will be the basis of drafting those particular provisions based on whoever it is that the client is that you are representing. And so these are more of them. And so that is what we're going to be talking about today. How to make it through some of these considerations. And so in my mind, what we need to do is to think about 7, and that's why I want to start talking about how technical it is. Because we have 7 contract concepts, those building blocks of contracts. We have 5 issues of client concern. You'll also see them called business issues. But then we have 10 contract sections. Some of them have some of the same words in the names. It can be a little confusing. And so these are things that I want you to be mindful of as you go along. That is why I asked you to do those, to double up on those exercises, because you will see how they kind of work together in the end. All right, so let me talk about these 7 contract concepts, okay? So here they are. You have your covenants, your rights, representations, warranties, conditions, your discretionary authority, and your declarations, okay? Eventually, you will see a section, a contract section that will be conditions of closing. See, that's not the same as this, you see? So let's be mindful of our 7 contract concepts first. All right. And remember, here's our little problem right here. Now, I want to use this problem because we're going to use this problem throughout the entire class. Now, I got some feedback from last time. You know, there are so many examples. We're using this example and that example, and it seemed like it was, you know, it may be helpful just to use one example throughout and build on the one example. So I'm wanting to use this, when you'll hear me call it, I'll call it Ralph's deal, or exercise 5.3. Whenever I'm talking about that, that's Ralph's. That's this. And so sometimes you will see that I isolate information. Like I said, the skill of analysis is a skill. I've been doing this for over 15 years. I still do the same thing. I briefcases the same way I did when I was in law school. And you have to isolate. I need to be able to see, okay, what am I dealing with? What am I being asked to do? You know, I'm always going to make sure that I isolate my call or the question. Because many of the reasons why students don't answer or answer the question correctly, or because they don't answer what was been asked, what they've been asked to do. What have I been asked to do? The call or the question. And so here is our Ralph's deal that I will be working on. And so the first thing I want to talk about are our covenants, okay? And it's a problem. I mean, it's a promise, okay, to perform. And there are going to be two types. You're going to have one that could be an executory type of a promise. It is going to be at closing, owner shall do such and such thing, or will do such thing. It is the obligation that this person is going to have to carry out in the contract. But then there will also be actual words are the performance. By signing this agreement, because there's not anything you can do with the licensing. You're licensing, you're giving somebody a license to use your trademark. You don't have to actually go and sell something or pay some money or do something. It is the actual signing of that agreement. It is a self-executing type of a promise, like a security interest. By signing a security interest, a security agreement, borrower grants by signing it, just by signing it. He doesn't have to go and do something. He doesn't have to do any performance. These are two different types of promises. Your covenants. And then once you have an obligation to do something, that is going to create in the other person a right to receive that performance. So then this right is like the flip side of the covenant. Some of these you're going to see they go hand in hand. So if Sam is obligated to perform in favor of Keisha, then Keisha has the right to receive that performance. If Sam is obligated to pay Keisha $200, Keisha is going to have a right to receive that $200 from Sam. Okay? And here are some other examples. The landlord shall heat the tenant's premises. Well, then that tenant is going to have a right to have the premises heated. And so I'm going to use this as an example here, okay? So I'm using number 1. I know that I asked you to do 2 through 8, but I'm just going to talk to you about number 1 right now. So as you can see here, you have Ralph LP will grant merchandisers a license for caps and t-shirts bearing the Ralph likeness. And then merchandisers will be obligated to market and merchandise them in Maine, New Hampshire, and Vermont. So now, for this first sentence then, if I'm asked to provide that contract concept, then the contract concept here is going to be a covenant for number one, for Ralph LP. It's going to be self-executing because it is by signing this agreement type of covenant that's going to be needed. And so then it will give merchandisers the right then to use that Ralph trademark image. I have this underlined because at some point I'm going to have a standards situation here because I'm not knowing it. I'm not thinking I want to use the word likeness. At some point I feel like I need you to define this thing. So that's why I have this underlined right here. The right to market and merchandise caps and t-shirts bearing the Ralph trademark image. See, as you can see in the writing of that, I want to say the same thing the same way all the time. Once I realize I'm not going to call it likeness, I may at some point define it as Ralph trademark image. That's what I'm going to call it all throughout. In the licensed territory, there may be some other thing that may need to have a standards issue attached to. So that's why I have that underlined. We'll get to that. So see, for this particular one, I need a covenant, a self-executing covenant for sentence 1. So then for sentence 2, what would I need? Anybody for sentence 2?
Right.
Okay, for sentence 2 now.
You need a covenant.
Yes, I'm going to need a covenant for this.
Mm-hmm.
Because, and let me tell you a clue. When you see the word obligated, that means that somebody's going to have to, that's going to be like a covenant. Now, it's not going to be this pretty in your transaction. This is where we're learning how to do this now. So for 2, you're going to need a covenant. Here, you need an executory type of a covenant. This is an actual action type of performance type of a covenant, promise, obligation. Obligating merchandisers to market and merchandise the caps and t-shirts bearing the Ralph trademark in the licensed territory. What else? This is like bonus. But what else would I, and let me tell you, the only way that I know this, as you can see, I'm going to show you how to do this, is because I've done my chart. But when I look at this, because I'm already looking for issues, okay? And so who is our client here? Ralph LP, okay? Now, this is all well, fine, and dandy here, but really, what promise does Ralph really want from merchandise? Yes, ma'am.
To sell, not just to
when he sells, what are he gonna do with that
money?
Gonna pay that money. So for me, I definitely can see, and we're gonna work through all this. But I see here, and you're gonna see later on, this is really gonna go in the subject matter performance provision. It is the creme de la creme. It is the Mac Daddy covenant of the agreement. There are some things you want to put there because it creates in each party certain kinds of, maybe what we call walk-away rights. So sometimes I want to put that thing, I want to slip that thing in the subject matter performance provision because I want to really bind that person. And so I want to put in this subject matter performance provision, this covenant here, I want to make sure that it is mentioned that merchandise is obligated to pay the client. Okay, so see, that's my client. So my job is to understand his goal. Now his goal, that's his goal right there. Everything else, he want to make sure that the brand and blah, 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 and this and that, and the integrity of the brand is well and good. make sure he get his money. So that is what I would definitely, I can see in my mind's eye, and a covenant obligated merchandise to pay a royalty payment to Ralph LP, given Ralph LP, because at some point we're going to define royalty. So now we have covenants. Now we're going to move on to that representation. That is a statement of fact as of that particular moment in time. I'm telling you this thing because I really want to induce you to enter into this agreement with me. So I'm just going to tell you all kinds of great things. That is a representation intended to cause reliance. And then you have your warranties. See, right now I'm just giving you just a splattering. Later on, we're going to go in depth into each one of these. But right now, I need to introduce you to them just a little bit. Your warranties. Now, there may be some instances, and as I have said to you, our objective in drafting the best agreement for the client is that we never end up in a situation it's supposed to stay in the desk drawer, never see the light of day. But problems, things, they happen. And so it may be that it turned out that that representation you made was not true. So then you could sue for, what we call misrepresentation or fraud. But it requires certain elements. And one of them is intent, first of all. And then reliance is another one. But then I may also sue for breach of warranty. For breach of warranty, you don't need the reliance aspect. And so that's why you see your representations and warranties in contracts. Sometimes it may be the client's goal that there is no warranty for this particular reason. But, you can sue for almost anything these days. So. And so that is the reason that you would have that, your representations and your warranties. That needing to prove signature or intent. That you intentionally told me this thing and it wasn't true. It's a high bar in some instances. So here are your representations and your warranties. All right. So now this is your chance, number 2. And so here, as you may well understand, Ralph LP has an ongoing concern about the financial condition of its licensees. It is willing to enter into this agreement only because merchandisers' most recent financial statements showed substantial financial strength. So Ralph LP wants the contract to reflect its reliance on those financial statements. Okay? In addition, he wants the right to terminate this agreement if merchandisers' net worth at the end of the fiscal year during the term of the contract drops below $15 million. So our first sentence is Ralph wants the contract to reflect its reliance on those financial statements. So see how nice they do it for us? They put little buzzwords in there. Reliance. So what are we thinking is our contract concept that we're going to need for that? Our representations. So we need this representation and warranty for merchandisers. Read its sufficient financial strength, but as of that moment in time, because a representation can only be a promise of something that is of that moment in time. It cannot be a promise of something in the future. And so he's saying, right here and now, yes, I have that financial strength. This was the This induced the reliance of Ralph LP to enter into this agreement. And so we want to make sure we prove that up in those representations and warranties. A condition to an obligation is a statement of facts that must exist before there is an obligation to then perform. Sometimes you're going to see the word if. See? The little buzzwords. And then I'm wanting to tell you again right here, please keep in mind, this is not the same condition that we're going to talk about later on when we talk about sections of a contract. The sections of the contract. This is a contract concept. It is a concept that we use to draft provisions in each section. So don't get conditions confused with these section conditions to closing. And you will notice that these conditions, as a building block, they are covenants. They're really basically covenants. And so here is an example. If, in other words, on condition that the retailer notifies the manufacturer that it requires additional merchandise, then, so this statement of fact must be true first. Then the manufacturer shall ship additional merchandise. Then the obligation to ship the additional merchandise comes into effect. But the condition has to be true first. Before that obligation, before that person is going to have that obligation. So it says here, merchandisers is to have an obligation to use commercially reasonable efforts to market the Ralph merchandise. If merchandisers has any unsold merchandise on hand at the time the term ends, Ralph LP will buy that merchandise at its cost. So what are we going to need here then? Yes, ma'am.
To a covenant and a covenant.
Okay. So here, you're going to need a condition to a covenant. Sometimes you'll see condition to an obligation, but an obligation, when you see the word obligation, you should think in your mind, oh, covenant. And a covenant or obligation of Ralph LP to buy back that unsold merchandise. Because then, and only then, will that obligation come into play. On the condition that there are any unsold caps and t-shirts. Now I'm going to come back to your. And then again, I want to make sure I let you know also that, again, when we have that covenant, then that's going to create in the other person a right. Just keep that in mind. You hear that? Do you hear that? What is that? Is that maybe?
Sounds like it's in the wall, like it's the AC or something, probably one of the fans.
All right, so now discretionary authority works in one of two ways. You have your discretionary authority that gives the holder a choice, or your discretionary authority gives the holder permission to act, often when it has been previously denied. You're going to see as your clue, may, a person may, you have the discretion to do this thing or not. Either party may terminate this agreement at any time by sending written notice. Or your second example, discretionary authority gives the holder permission to act, often when it has been previously denied. The borrower shall not invest in any person, except it may invest in itself. In other words, obviously, the borrower may not invest in any other person, but you can't stop a person from investing in his own company. So this is an example of this discretionary authority. If he wants to, then he may. And so then you can also have a condition to discretionary authority, which is a statement of facts that must exist before a party may exercise that particular discretionary authority. So, and that's usually how you're gonna see it. If there is an event of default, if there is a default, so that default, the event of the default has to occur before that discretionary authority will be applicable. The bank may then exercise the following remedies. And so then, or if the author does not submit her manuscript to the publisher on or before the deadline, then the publisher may exercise that discretionary authority and accept or reject it. And so here is that sentence number two, problem number two, sentence number two that I asked about earlier. The right to terminate this agreement if merchandiser's net worth at the end of any fiscal year during the term of the contract drops below $15 million. So then here we are, first of all, we're going to have that condition, discretionary authority, and discretionary authority. If, on condition that merchandiser does not meet its obligation under its covenant to maintain that net worth of $15 million or more at the end of the fiscal year, then Ralph LP has discretionary authority and then may terminate. And then we also have declarations. And so when it says it's a statement of fact, which both parties agree to, but with respect to which neither party has any right or remedy, it just only means that, these are like definitions or declarations. They don't really bind anybody. When you start getting to, we're going to see section 3, those business like action sections of the agreement. Those are the sections that start to have the covenants and obligations that are going to bind the parties. Your first preliminary parts of the agreement are, declarations. You have some declarations in there. They're like definitions. But it is the subsequent sections of the agreement that will kick those definitions or declarations into effect. And so you'll see this in, like, for example, the purchase price. This is a definition. Purchase price means $200,000. And so now this to me may not be that great of a definition, because this is actually a definition or declaration that you're going to see in the action section of the agreement. But then that is going to be kicked into action when you create that covenant. The buyer shall pay the seller the purchase price. We know what the purchase price is because the purchase price has been defined to mean $200,000. So that is what it means. Not necessarily that they're not important. They're very important. But it is the covenants, the actions, the business sections of the agreement that then bind those particular declarations. By creating that contract concept, covenants. And so here we have the number 2. And so what here, I'm just going to ask, what here would we need a declaration for? Maybe. I'm just saying, maybe. Yes, sir.
Maybe the net worth?
Yes. You want to define what net worth declaration to define what that means. This is how we draft contracts. We use concepts. And we're going to get information from the client, and then based on what the client wants to do, the client's goals, we're going to use contract concepts to draft provisions in the various sections of the agreement. And this is how we go about do that. We have to think about writing the contract. It is really the gravamen of the actual process. Because you just don't want to be just writing just for the sake of writing. We don't just want to be writing just what we want in there. We have to be mindful of the client's goals. Net worth, well, we want to define what net worth is so that people won't get any ideas, merchandisers, what we mean when we say net worth. So that is what you would need. I would think I would need a declaration, a definition of net worth. All right, so now we have our 7 contract concepts, and now we're going to talk about 5 issues of client concern. Business issues, that business issues framework. And here they are: money, risk, control, standards, end game. And so you got that exercise, and how did y'all like that? Did you love doing that? I want you to love doing that exercise because I want you to use it. Sometimes at the end of the semester, we'll be talking about a transaction, and I won't see anything in that agreement that had anything to do with issues of client concern. And it's because people threw this thing away at the beginning of the class. After they did that the first time, it was like, I'm done with that. But I want you to use this on all of your agreements. I want you to, get in the habit of what we call adding value to the deal, finding business issues, and then resolving them. Okay? Ralph, he has a little memo. He wants, telling us what he wants to do. There may be some issues in there, and it's our job, it is your job as the attorney to resolve that issue for the client, because if the client goes out there and ends up with a mess, well, you don't want that. Okay? And so it also involves looking at the contract from the client's perspective. From the client's perspective, not my perspective. It can't be, but I can't judge it. Once the client gives it to me, I got to make it happen. That's what you have to do. And the most important thing that you're doing is you're wanting to avoid risk. And so that is why we're giving you this framework here to use, that I want you to use when you are working on your issues of client concern. Okay, so I'm going to talk about a few of them. So we have our money issues, okay? And, there could be all different kinds of, money issues. It, may be that, you need to, if somebody is saying, I'm going to pay you a royalty. Okay, well, when are you going to pay me? How are you going to pay me? Money issues. Okay, if you have funny credit, I may want you to, give me my money sooner. Just all different kinds of things. But we need to know based on the facts of the scenario. There could be credit risk issues. Payment formula issues. After you, do all your business with the merchandising and you selling I need to, where am I going, with 15%, how are we going to, calculate? These are money issues. And I'm not going to be able to go through this today, so move through this. All right. And then risk. Might be able to go back to it. But there are different kinds of risk. You'll have your tort liability risk. For example, okay, well, if somebody comes and says that, you know, they have a right to this trademark and that you really don't own this, Ralph LP, well then they're going to sue me as merchandisers. Tort liability. And so it is our job to look at the scenario that we've been given and to evaluate any risk that we may see that may be on the horizon. And that is the job of the control, because that is what control is all about, controlling the risk. Once I see what the risk is, then I need to determine how in the agreement, what kind of concept I'm going to use, where am I going to use it, where would it be best to use it to control that risk. I might need a representation and warranty. I may need a covenant over here in the indemnification section of the agreement to control that risk. And so where there's risk, you are going to have to control it. And so there are different kinds of ways to do that. You'll see when Ralph's deal, there is some talk about defense and indemnification in the event that there are any third-party claims. Some party may need you to deposit money into escrow to hold it while they are, considering some things during the term of the parties' negotiations in the agreement. And so these are ways that we control risk. And then you're going to have your standards issues, and this can be any word, every word in the agreement is going to turn up, because you're going to read that thing and you're going to say, okay, now, do I need to qualify this by saying, okay, the car is in good condition, or it is every word of the agreement, every adjective, is it in good repair, or I'm going to just deliver it, I'll deliver it, or prompt delivery. So these are ways to determine whether there are any standards issues that need to be considered. These are just examples, for a representation type of a standards issue. The car has new tires, or should I say here, to the best of the buyer's knowledge, the car is in good operating condition. Okay, and you could just say the car is in good operating condition, or as far as I know, the car is in good operating condition, because that can be a reliance issue. So that's standards. It may determine whether you want to be a little bit more vague about it or not. But don't judge it in the beginning. If you have to look at the goals of the client to determine whether or not you need to vary a standards issue.
Ms. Sears, why don't you go ahead and tell me a little bit about why you're here today?
Thank you, Your Honor. I am part of a company. It's a record label called Headspin Records. We have 17 clients under our roof, and they're artists that are up and coming. And one of the ways that we get their music out there is by having concerts, outdoor concerts. And this year, what we've done is we've had 17 of our artists come out and perform with used guitars. So the lead guitarist of that band would be playing that used guitar, and then after the concert is over, the entire band would autograph that guitar and it would be given away to one of the members of the audience. Unfortunately, out of the 17 guitars that we purchased from this gentleman, 9 of them were not functioning. When we went to find them and purchase them, he claimed that they were in decent shape.
Now, did you purchase them personally?
Well, I have a production coordinator who did that for me, and his name is Phil Spencer, and he went out there and spoke to Lenny, and he said that he needed these guitars. Lenny said he could get them for him, and so after about 2 months, we finally got a phone call, which was actually 3 days before the event, and said that he finally got all the guitars, and my production coordinator went over there and tested them out, and then they were couriered to our office before the concerts.
Okay.
So I did not actually physically speak to this is the first time I'm meeting this gentleman.
Okay, so you spoke to your employee.
Yes,
who
my
told
employee,
you.
he was our middleman.
Okay, okay. And, okay, why don't you let me know what happened that day when, what was his name again? Phil Spencer visited your shop.
Well, this guy come in, he asked me for a number of guitars, I think it was 17, used guitars, he wanted decent ones.
Had you ever met him before?
Never. So he wanted these used guitars, very decent quality, he said decent quality, and I said, okay, you know, kind of a tall order because, you know, most of the guitars we get in are real junk. So I had to go, I told him it's going to take me a little while. I'll search around, go on the internet, blah, blah, blah. And next thing you know, I got all the guitars, you know. And I called him up, he said he didn't need it till like, I don't know, July, I think, 21st. So we didn't have a deadline other than that. So as soon as I got my, the last guitar, which I tried out, I mean, I got plenty of them, and I sent some of them back. But, because they weren't good.
Now, you sent other ones back because they weren't good, but you
Right.
kept some. Okay. Did Mr. Spencer tell you what they'd be used for? What kind of condition they'd have to be in?
He said decent, playable.
And to you, what does that mean?
That means decent and playable. It means, you know, you plug it in, bing, bang, boom, it's music comes out.
But 1 second, did you know what these guitars were going to be used for specifically?
He said that they were going to have some kind of a contest or something, and they were going to be giving the guitars away. Yeah, he said something, yeah.
Okay.
I know for a fact, Your Honor, that Phil went in there explaining that they were going to be used in an outdoor setting. Therefore, they had to be amplified.
Yeah, he told me that.
Okay, so when a guitar is played, it has to go past volume 5 in order to work. The distortion, Your Honor, was so intense, dogs were coming from 3 counties around with this high frequency noise. I mean, it was incredible.
Can I say something?
Decent shape,
Decent. They were all decent.
they weren't working.
Well, first of all, Phil Spector, or Spencer, whatever his name was, so he tried to act like, come into the place and he plugged them all in and tried them right in my shop. And it's not, I mean, he went
Inside your shop.
Of course. Well, listen, we didn't take it out onto 8th Street. I mean, and he plugged them all in, and each one that he tried worked and was fine. No distortion whatsoever, not in my shop.
Mr. Raven, let me ask you this. How long have you been in business?
22 years.
And what is your return policy?
My return policy on brand new items is the manufacturer's warranty. On used items, I got a big sign right over to my cashier. It says no return policy, no return at all on used merchandise.
You have a sign stating no return on
As
used
big thing
items.
that we trust.
Okay.
Your Honor, if I may say something else, I understand that there's a sign there, but usually when you promise something, that's what you're supposed to get, okay? So if he said it was in decent shape, then they should be functioning. And 9 of those guitars were not functioning. That's more than half.
Now, when you say not functioning, you couldn't use them to give them away?
Well, no, well, that's the problem. We were at the concert, we had the sound check, and the band started to turn them up past volume 5, And it was like a Nirvana concert. I don't know if you know that hard rock metal band, but it was not plausible to the ears. And my bands that I represent were very upset. They did not get to perform the way they needed to perform.
Okay, ideally, what would you like to, how would you like to resolve this matter?
Well, I would like to be compensated for those 9 guitars, which I think is approximately $437 per guitar. Out of the $7,500, it's about $3,933, roughly. But to be honest with you, the reason I'm here is I would like him to at least get more than that, a slap on the wrist. I mean, this is a shady proprietor and a shady merchant, where who knows where he got these guitars. It could have fallen off of a truck on their way to a repair shop or to a guitar funeral or something, because they were not working, Your Honor. And I've lost a lot more than the financial aspect.
Okay,
Can I say something here, or
yes,
what?
Mr. Raven?
Oh, well, I just want to say that, first of all, I don't know who she has on the bill, but all I know is that a lot of musicians that come into my shop are morons. They don't even know where to plug a guitar in.
These are professional musicians,
Well,
okay?
all right, 2 things. Number one, I don't know who these people are, whether they plug it into the wrong hole or not. Number one. Maybe they plug it into distortion. Number 2, I don't know what kind of amp
So
they
are
were
you
using.
saying that you think that they possibly could have damaged the guitars after they left your shop?
Without question. Are you kidding me? Listen, this Phil Spectrum guy that was in there
Spencer.
plugged every single guitar in, and every one of them was working, and he wrapped them up and took them with him. I mean, personally, I think that if they weren't working to his satisfaction, he should have said something right then and there before we went through the transaction.
All right, I've heard enough. I will return with my ruling.
Thank you.
Thank you, Your Honor.
Okay, have y'all heard enough? Okay, so after all of that madness, what word comes to mind? It's just one word. Yes, ma'am.
Decent.
Decent. Somebody needs to determine. She even said decent. Well, okay, decent is decent. If you want something more than decent, you might need a standards issue. You might have a standards issue. And you may need to define that a little bit better. And instead of saying decent, then you need to say what shape those guitar. First of all, you need a written agreement. That's what happens when you don't have it. Second of all, you need a standards issue. That creates a standards issue right there. Decent. You come in and tell me decent, I'm be like, okay, decent. But if she says she's never seen it before, how does she know what was said? So these are the kinds of things that you want to be mindful of. Depending on who you represent on this, if this is your client, the lady there, then you need to determine her goal. Her goal is not really decent. She wants something that has a better quality, just used, but she wants something that has a better. Don't say decent. And so that is something that you need to have a deep understanding of the client's goal when you are drafting that contract. And then you're going to have your in-game issues. And it can be, it could be just the end of the agreement. And if the parties had a good relationship, then it'll just be the issues of wrapping up the parties, settling up whatever needs to be settled. Or it may be that it may be a termination in-game issue. And so I'm just briefly giving you some of these issues of client concern that we will deal mostly with throughout this class. And so here is our chart again. And I think let's see. So I want to start with number one. Well, I'm going to start with number one. Okay. And so this is how I am looking at my number one. See, for me, I don't want to do exercise 25-1 on another problem, then come back and do 5.3. I want to show you how you really need to put it all together to understand. I mean, it's going to help you to put it all together to understand, you know, how you go about isolating those issues of concern. And you can see here, I like to put mine in the box, you know, where I will take my concept and I'll try to put it in that box over there with the issue of client concern that it relates to. So I have Ralph LP will grant merchandisers a license for caps and t-shirts bearing the Ralph likeness. So I can see that I'm going to need a covenant. We've established it. And it needs to be self-executing of Ralph LP granting merchandisers the right to use the trademark image to market and merchandise caps and t-shirts bearing that Ralph trademark image. But see, now I'm beginning to see here, okay, as I go along, I may need to, so there's going to maybe a standards issue regarding exactly what can bear that Ralph likeness. It's only going to be caps and t-shirts. Don't try to put it on socks and towels and everything else. Caps and t-shirts. So that is creating a standards issue because, you know, if you don't tell a person, they'll try to do whatever. You know, they'll go out there and you'll see it as on a teacup. Ralph on the teacup. No. Caps and t-shirts. Okay. So then I would have a covenant that would would give the obligation on exactly what can bear that Ralph likeness. Or there may be a standards issue I can see here regarding the definition of the, I don't want to call it Ralph likeness throughout the agreement. I want to make it clear what I'm talking about is that Ralph trademark image. And so I can see now, I'm in my declarations, I may have a definition, Ralph defining what I mean by Ralph trademark image. Or, so here, eventually, you can see where we say merchandisers will be obligated to market the merchandise then in Maine, New Hampshire, and Vermont. So I can see I need to define what the license territory is at some point. It's a standards issue. But also, it is, to me, that's how I was able to see that earlier, is a money issue, because I know for a fact that Ralph LP wants to be paid his royalty. And I am definitely going to have that at some point. You'll see in that section 3, action section. But there are certain things you get from having covenants in, what we'll see later, that subject matter performance provision. And so I don't want to say this, definitely defining royalty, how much it is, you know, when it will be paid, all of that, in the payment provisions, that's one thing. But I want this covenant to also be linked. For me, I can see this. For me, that's a money issue. I'm seeing that now that I have it on my chart. Because what are my goals? Money. Okay? So I can see that this is a possible money issue. I'm only going to see that from putting this this on my chart? Because ask yourself, how many of you put that on your chart? That's just a question for yourself. But when you put it on your chart, when you start to develop that thinking skill, the ability to spot client issues, because you're going to sit back and you're going to say, okay, yes, he sent me, his little thing and telling me all about what he wants to do. But you have to be able to go deeper and say, okay, what's this really all about? I mean, what is this? I mean, people want to make money on both sides. Merchandisers wants to make money, but who is our client? Ralph. That's what we need to be concerned with. As you go along, you'll see certain little issues for Ralph's. That's fine. But you need to understand who your client is. Okay? All right, so then for number 2 then. I'm going to let y'all do number 2. So number 2, what do we have? Okay, let's say Ralph LP wants the contract to reflect its reliance on those financial statements. Okay, so we've already done a little bit of work in here to understand what concept we have, but do we have any issues of client concern from that? Yes, sir.
I think we'd probably want to make sure that those financial documents made their way into the contract.
Okay, so what kind of issue is that? What kind of issue is that gonna create? Ralph LP wants the contract to reflect its reliance on those financial statements. Why? That's what you gotta ask yourself. Why? Now, why does he want that? Sometimes I'm gonna have questions. I'll have questions, more questions than answers sometimes. And it's gonna get on your nerves. You're gonna think that I am, no. I'm trying to develop a skill. You see something, it's not going, you have to say, why? You need to be always asking, well, why? Ralph wants the contract to reflect his reliance on those financial statements. Why?
A couple of them, risk,
Risk. What kind of risk?
future litigation, credit risk.
Okay, but look, what does Ralph really want to do? He wants to do what?
Make money.
Okay, so now if this company doesn't have the financial strength to market and merchandise, what's going to happen to little Ralph? He ain't going to make no money. And his chance to have made it with somebody else is gone. It's on hold because he's messing around with this merchandise guy. Okay, so that's risk. Okay, so how is he going to control that risk? We've already talked about this, so we should know. How is he going to, this risk, so how's he going to control that risk? With a what? What's that concept? A representation. Representations and warranties. What other risk is there here? I mean, there's a risk there, but what other issue is that we talked about? Money. That's a money issue. Loss of money. If he doesn't have the financial strength. So that's when I start to put that in that box, that starts to get my mind thinking of what kind of contract terms I need to draft to further Ralph LP's goals. That's my job. Okay, that must be my power. Okay, what about this one? I wanna go to this one before I reveal. Ralph L. Pease wants the right to terminate this agreement if merchandiser's net worth, as at the end of any fiscal year during the term of the contract drops below $15 million. What kind of issue does that raise? Number one, money. Don't be shy, y'all. Money. What kind of money issue here, though? This says Ralph wants the right to terminate the agreement if merchandiser's net worth at the end of any fiscal year during the term of the contract drops below $15 million. So that's a money issue. What other kind of issue is it? We talked about earlier.
Risk of insolvency or something?
No, we talked about it earlier. I'm gonna go ahead with these. A standards issue, this one. Remember? Standards. Definition of net worth. So see, this is how I put it all together. And then when we talk about termination, when you use the word terminate, that's always going to mean end game. It could be a possible end game retermination if merchandiser does not. Then Ralph LP has a discretionary authority and may terminate. That's end game. What about number 3? This agreement will have a 3-year licensing term to begin on the first day of the month after the end of this month. And then, so we're going to please assume that tomorrow is when we're going to sign the agreement. This agreement will have a 3-year licensing term. What kind of issue does that create? Anybody? Help me. Some of you all turned your thing in. Do you need to keep it? Do I need to give it back to you? Okay. That's why I wanted you to bring an extra copy so you could read off of it. Anybody? Yes, ma'am.
Is it a standards?
Okay, let me see if I have a standards issue. Now, number 3 is going to be a standards issue regarding what?
Well, like the exact timing that the...
Yes, when it starts and when it ends. The term of the agreement. Defining that term. Okay, now, what other issue does this create? It has a part of a word that I just used earlier. Yes, ma'am.
I was going to say it's an end game.
End game. Because at the end of the term, what's going to happen? It's going to end. Game. End game. At the end of the term, it could create, you'll learn this later on, what we call a friendly termination event. Because we all friends. We're just going to pay our little money, going to settle up and go on about our business. Yes, sir.
Arguably, each of these could have something to do.
Could, yes, could.
Where is the, like this one, I could say is agreement for a 5-year term, and I put establishes the schedule of payments. But really, that's.
Yes, that's, what do you mean, a schedule of payments?
Well, because
So what I need you to do, so what you're doing though here is you're learning how to, so we're on number 3 right now. So these are issues that relate to this. This and only this. We're learning how to spot an issue based on, a fact, right? Or a goal.
I think I got that confused with the payments.
Okay. So I want you to
Okay.
focus, see,
I'm sorry.
this is how we're gonna learn how to do this, is to focus on this issue right here. I'm not saying, we're saving yours for later. But for this, I want you to see how you can determine what issues of concern relate to this. Because now you have to go in and draft the contract for the client. Okay, so we've already determined that we have our standards issue where we're going to determine, okay, it's going to start on this day, it's 3 years, it's going to start on this day and end on this day. So we're going to need probably some type of a declaration for that, and then you have an end game issue, which we're going to talk about more later on at the end of the, the course. Are there any issues that we can see in number 4? Okay, so we're going to have a covenant about what?
To market the merchandise reasonably.
Yes.
To that.
Merchandisers' obligation to use all efforts to sell the merchandise. Okay, so you're going to need to have some type of a covenant there. And I'm saying over here, I'm saying it creates a money issue. Because if he doesn't, then that's loss of money. So you want to have a covenant over here in your money. I'm saying over here, but this is where I'm putting these. You see, because it helps me to visualize where the issues are. And it helps me to visualize later on where I may need to put the covenant in the agreement. Okay? So if he does not use every effort to market, then that's going to create a money issue for Ralph LP. You had something.
I was going to say the same thing with the standards issue for
Okay.
reasonable effort.
Okay. Yeah. So I don't know how you would define that, but that might be something good to define, though, now that I'm thinking about it. I didn't necessarily have that, but I don't know how you could definitely, say what it is that he has to do, if that is something that, and that's good. That's very good. What about here? If merchandisers has any unsold merchandise on hand at the time the term ends, Rouse will buy the merchandise at its cost. What kind of issue does that create? Money. It's gonna go, I'll put it right here. So this is how I think I got some of those kind of mixed up. But I put it right here. My condition is an ongoing condition to an obligation, and an obligation or a covenant on this condition. It's going to create a money issue for Ralph. To me, this may create some possible risk issue if merchandise is found not to have performed its obligation to do everything to sell the merchandise. So I may want to control that. Whenever you have a risk, you got to figure out how to control it. I may want to control that possibly by creating some type of discretionary authority if this occurs prior to, see if it occurs at the end of the term. I'm just now realizing that at the end of the term now I got to pay this money back to buy all this stuff back at my own cost. It's at the end already. But if I find this out before, I need to have maybe some type of way to control that with some type of, discretionary authority of some type. This is how I begin to see my issues, by put them on my chart. Now, it's, to each his own, I'm not judging it. These are mine, you have yours. Are there any questions? All right, so number 5, merchandisers want some kind of assurance in the contract, A, that Ralph LP actually owns what it is licensing. Okay, so what's that? Definitely. And this is merchandisers now, you see. And so we're doing what the client is asking us to do, to put that in there. But what kind of what kind of issue does that create then for merchandisers? For merchandisers. Yes, ma'am.
I thought it lessened the risk for merchandisers that they will be
So what kind of issue?
risk.
Risk. Okay, yes. Go ahead.
I thought it would lessen the risk of being sued by a third party if the license isn't theirs and they're selling product with the.
And how? So how do you control that risk?
Well, Ralph would have to show that they own the licensing, so maybe they can
How?
show a
What kind of
certificate.
concept? Concepts. By doing what? Providing to
like a warranty.
a representation that he owns that trademark. See, right now, we're going through our concepts and our issues of concern. We're matching them up to determine what kind of provision you're going to use these concepts to draft provisions. Okay? You see that risk there, you say, okay, that means I might need a representation and warranty to control that. Okay? All right? Okay, so here B. That during the term of the license, Ralph LP will, 1, enforce its IP or intellectual property rights against any third parties, and 2, defends its licensee, i.e. merchandisers, against it. Okay, so what kind of issue would that create for Ralph's? Money. Because why?
It's expensive.
They're going to have to pay somebody to defend merchandisers against any third party claims. They're going to have to pay to defend their own. Their merchandisers is asking Ralph LP to defend, if anybody comes against him, to make sure he defends himself, and to defend merchandisers if anybody comes after merchandisers. That's money. That means money. That's going to create a money issue for Ralph, because they have to pay money to find lawyers to do that. What other kind of issue? Okay, so we're going to have our risk up there, but this, what is this? That during the term of the license, Ralph will enforce its right. What other kind of issues does this create? This might create some type of a standards issue, because you have to, it just can't be defense and identification. You have to say, okay, you're going to use our lawyers. Our lawyers are going to have the authority to make the decisions about these claims. We'll have settlement authority, we'll go through appeal, the ifs, ands, and whats, the buts and whats about the identification. How much? Is there a limit on it? Up to $1 million. So I don't know. But I cannot visualize these ideas without putting them on my chart. All right, I gotta move. Some of these somehow got mixed in. So, at some point, you're going to need a covenant, read Ralph's obligation to defend and indemnify. Okay, that's probably going to, be, in, one of the later on business sections. Standards, redefinition of specific, see, that should go in the specific term of the indemnification. That's what that really should say. Okay. So number 6. The parties have agreed that with respect to each year of the term of the contract, merchandisers must pay royalties equal to 15% of all net sales. What kind of issues do we see here? see in the next class, I'm gonna call on y'all. Yes, ma'am.
I think it's a money issue.
Yes, definitely money. Okay. So what do we need? What do we need to? What concept are we gonna have though?
We're gonna need, well, it's kind of a standards issues too, because you have to consider what net sales is going to be comprised of.
Okay. All right, but okay. So, but first, and that's good. But first, you definitely want to determine what the net sales are. But first, you gotta define what the payment is. In some contracts, like a car sales agreement, it'll be the purchase price. But here, we need to determine what it's going to be called, and we determine that it's going to be called a what? That R word. A royalty. Okay, so you have to define it, okay, first. And so with that being said, then that means that you're going to have to either do it one or two ways. It'll either be a covenant determining the obligation of merchandisers, or it'll be a declaration that'll say how much. See, right now we're saying 15% of our net sales, and a declaration and a covenant combo, because we determined over here that we need to define the royalty first. And so we'll do all of this as we go along. Later on, you can have a declaration that will define your how the net sales will be determined. So you'll need a definition to determine your net sales, and then you'll need a covenant to kick it into action, to make it an obligation to pay it. Yes, sir.
Wouldn't you also want something that, the only thing I was noticing about that was, like, what if the sales are inadequate? That's a money issue too. If they'd be stuck in a contract where these people aren't selling anything, even if despite their best efforts for commercial,
absolutely.
sales.
Yes, absolutely. But see, right here, we got to focus on this right here. So that's definitely going to be an issue. But for right here, the parties have agreed that with respect to each term of the contract, merchandisers must pay royalty equal to 15% of net sales. Right now, we're just dealing with the how to get this into an obligation that'll make it into something. And then once it's determined that that is not happening, then obviously, hopefully, we'll have some type of eventuality in place. That's why I was saying earlier, it would be a risk to wait until the end to determine that he's not using every effort. And so that's a risk as it related to that particular piece. But here now, we want to see what kind of issues we have just right here. And so here are some of them. There could be more. I mean, you could put your issue there, but you have to ask yourself, where am I going to put it, and how, if it's a risk of any type, how am I going to control it? You would have to determine that. Okay, number 7. Okay, Ralph LP has a reputation for being crazy and always requires licensees to submit samples of any item it intends to manufacture at least 30 days before the item is to go into production. Ralph then must either accept or reject. Okay, so what do we have here? He says he's kind of crazy about always requiring. So what does that sound like? Don't be shy. Anybody? Yes, ma'am.
Is it a risk?
ultimately, then what's going to happen to the brand? It's going to diminish the brand. Yeah. And so how do you control that? We're controlling that by creating an obligation in merchandisers to submit. That would be done with what? What type of concept? A covenant. All right. So I'm going to move on through because I need to get to the end. I'm going to move on. I'll post later. But now we need to talk about the 10 contract sections. Okay? These are the contract sections that we will be focusing on throughout this course. Okay? That's what I mean when I say sections. Okay? Don't get this confused with concepts or issues of concern. And so when you put that all together, I have my building blocks, my concepts, I have my issues, my business issue framework, and now I have my my sections. So as I consider my sections, I want to look at it all together. Here, you can see here how when I look at that standards over there, that standards issue, I know here I am going to need a covenant. I know because, I've been doing this for a while, that this is going to go in the action section. When I say SMPP, this is going to go in the subject matter performance provision. This will be a covenant on the one hand telling me this is the main covenant of the agreement, the subject matter performance provision, telling me what each party's consideration is in this agreement, what the agreement is about, what promises, what the parties are entering into this agreement for. And then here, these covenants regarding the obligation to market and sell, these are probably going to go, this is going to definitely go, because this is the reciprocal promise from merchandisers. So in that subject matter performance provision, you're always going to have what the one party is promising, what the other party is promising. You got to have both of those in there. Some people get a little annoyed with me when I keep saying to them in their transactions, they only have one side, what one person is going to do. And so that's why I want you to pay attention to the comments that I will give you on your transaction, because if I look back in transaction 2 and that same thing is occurring, that means that you don't have everything you need in that subject matter performance provision. Is critical. Okay? And then here I say, I have this definitions, that declaration that I'm going to call the trademark image. That's probably going to go in section 2, the definitions. So see, later on, when you go back and throughout the course, you're going to be asked to, okay, now I want the definitions for Ralph's agreement. You should be able to have it all here. And just go back now and say, okay, and then you draft your provision that you need. That's how you should be able to do. And so here you can see, okay, so that's section 4, representations and warranties. Section 3, business. Business is different from actions. Section 3 has your actions and your business, but your actions are for specific things. Then your business sections, your business provisions. So see here I can see, okay, termination, that will be section 6. So this is how I put it all out on my chart. All right. So I'm moving through because I need to talk a little bit about transaction 1. Okay. Now, I am, this is one of those things that I'm, want to make you mindful of is that you're going to get a whole lot of information here. It's like a puzzle. It's your job to go through here and get your instructions out, get out the facts of whatever it is that relates the client issues or concern. But what you should, here are your student instructions, and it's telling you specifically for this first transaction what sections are here. We have 10 sections that we would be mindful of throughout the course, but this is just our preliminary work that we're doing. We're only going to be dealing with these sections. And so these are the sections that will be in that first transaction. Not all 10. Okay? So I just wanted to make sure I pointed that out. Okay. Are there any questions